704, opinion on an ultimate issue. Not reading the rule, what do you think that means?
Did he do it?
Yeah. It basically, whether or not an expert can testify to the ultimate issue. If you're here to murder, whether or not he committed the murder. That's not what the rule says, at all. The title is misleading, and the rule is very confusing. So bear with me here.
I knew that for the record, though. Just
What,
at a
that-
glance, I was working with you, though.
Yeah. 704 is an opinion on the ultimate issue. 704A specifically says that except as provided in subdivision B, testimony in the form of an opinion or inference, otherwise admissible, is not objectionable because it embraces an ultimate issue to be decided by the trier of fact. In other words, just because the opinion says or contains, I think he did it, doesn't make it inadmissible. It doesn't necessarily mean that your expert can testify that the defendant murdered his wife, but it's not specifically objectionable just because that's what it says. Are we clear on that?
Is it basically like saying because he's an expert witness, just because he's an expert opinion, he can give that type of opinion because he's an expert, basically?
I don't think I understand your question. Are you asking, like, what's the theory behind the rule? Like, why have a rule that allows you to give that opinion?
Yeah, like, is it basically saying just because he's an expert, he can say that, but a lay witness couldn't?
Well, I mean, that's the standard for allowing... yeah. The real answer is that that the rules of evidence are pro-admissibility. And really, you know how, like, we went through a lot of these rules, and a lot of times it imposes these standards on certain things, but they're very low standards. Like relevancy, for example, is the best example. The words are any tendency to make any fact at issue more or less probable. It's a very low standard of relevance. Just about anything's going to be relevant. The theory behind these rules is that the more evidence a jury sees in front of them, the more likely they're going to come back with an accurate verdict. So, the theory behind 704 in that context is if a jury is going to, if an expert is able to give that conclusion, provided that it's based on sufficient facts or data and that they applied those reliable principles and methods to the facts in this case, then it's really just the icing on the cake. It's not so damning that it should be just kept out all in all. Does that answer your question?
So it's like, because he's built up so much of a case towards that conclusion, he can give that conclusion.
Right. But keep in mind, the rule doesn't necessarily mean that it's admissible. It just means that it's not objectionable. In other words, the language really translates to you can't object. You can't. Your words out of your mouth cannot be objection, opinion on the ultimate issue. That's not a proper objection. Your opinion, your objection would have to be objection, relevance. Your Honor, this bears on no material fact at issue, which you're going to lose because if it embraces an ultimate issue, it does. However, Your Honor, if Your Honor finds that it's relevant, the danger of unfair prejudice substantially outweighs any probative value. The fact that a jury is about to hear this doctor testify that he killed his wife it's substantially prejudicial. The bell will already have been rung, and at that point, I reserve my objection on 403 for the duration of this witness's testimony, something like that. Like, that's the way you'd have to object to an opinion on the ultimate issue. You couldn't really object. You can't object. Objection, improper opinion on the ultimate issue. That's not a proper objection. Unless you're in subdivision B. That says, no expert witness testifying with respect to the mental state or condition of a defendant in a criminal case. No expert in a criminal case that's testifying to the mental state in a criminal may state an opinion or inference as to whether the defendant did or did not have the mental state or condition constituting an element of the charge. What does this mean? Every crime has, every single crime, unless you're talking about strict liability crime, has one thing in common, which is what?
Elements.
every crime has one element in common. Intent. It's talking about intent. Subdivision B says that in the context of a criminal case, you cannot have your expert get up there and say, he possessed the requisite intent to commit this crime. At that point, he knew, if you're talking about murder or first-degree murder, like Casey Anthony, for example, their expert, unless you're Jose Baez as the attorney, cannot get up there and say, oh shit, that was a tape. Their expert cannot get up there and say, she had the intent. She formulated the intent on July 12th. And it was for the next 17 days as she perpetuated the lie to hide the fact that she killed her daughter. That language cannot come out. Although it can be inferred by other testimony, the language as it is cannot come out. And that's the difference between 704A and B. Taking a step back, what does that mean for this in the context of a civil case?
Nothing.
Well, it means something.
You can talk about the intent or something.
Kind of. If you are in the, for example, defamation. Defamation imposes a malice requirement. You have to prove actual malice, that they intentionally published a false statement with knowledge that it was false, or a reckless disregard for the statement's truth, or the truth of the statement, or something like that. You can have someone who is an expert in defamation law or whatever get up there and say, look, they knew that it was a false statement, and they did it deliberately. They did it intentionally. They met the standard. You can have a witness get up there and do that in a civil case. The theory is that no one's going to jail. So no one's freedom is on the line, so we're going to be a little less stringent with the rule. But in a criminal case where someone's life is on the line, possibly, they're not going to allow even the prosecution to just win an element on one word like that, on one statement like that. All right? Rule 705, ignore. All right. Those are the 700s. They're short, but they are very, very complicated.